Hi friends, in this video we are going to deal with the case summary of the important and latest Supreme Court judgment pronounced now in the area of criminal law, that too in relation to right of private defense. To know more about it, please watch the video fully. If you feel that it is useful to you, please like, share and comment, and don't ever forget to subscribe to it, and further click on the bell icon next to subscribe button.
Hello everyone, I am Advocate Shweta Singh, practicing in Allahabad High Court since 2012. Today we are going to discuss an important judgment titled as Mahadev versus the Director General, Border Security Force and others, pronounced on 14th June 2022. The Supreme Court has held that an accused who takes up the plea of self-defense need not prove it beyond reasonable doubt, and that it would suffice if he could show that the preponderance of probabilities. The facts of the case would be that the appellant, who was serving in BSF, was tried for committing an offence under section 46 of the BSF Act, that is to say, murder punishable under section 302 of the Indian Penal Code. General Security Force Org rejected his plea of private defense and held him guilty of the charge and sentenced him to suffer imprisonment for life besides dismissing him from service. The convening officer confirmed the findings and the sentence imposed on the appellant. Agreed by the said order, the appellant preferred a statutory petition which was dismissed by Union of India, and the same was upheld by the High Court. Being agreed, the present appeal has been filed with allegation that the High Court erred in concurring with the findings of the GSFC and discarding the defense taken by the appellant, that he was compelled to exercise his right of private defense to save his life when suddenly confronted with intruders who were armed with weapons and groped him. The singular question that requires to be examined in the present appeal is whether the appellant was entitled to exercise the right of private defense in the given facts and circumstances of the case. The Supreme Court has held that the provisions that deal with the right of private defense have been enumerated in sections 96 to 106 of the Indian Penal Code and fall under chapter 4 that deals with general exceptions. Section 96 IPC states that nothing is an offence which is done in the exercise of the right of private defense. Whether a person has legitimately acted in exercise of the right of defense given a particular set of facts and circumstances would depend on the nuance of each case. For arriving at any conclusion, the court would be required to examine all the surrounding circumstances. If the court finds that the circumstances did warrant a person to exercise the right of private defense, then such a plea can be considered. Section 105 of the Indian Evidence Act 1872 states that the burden of proof rests with the accused who takes up the plea of self-defense. In the absence of proof, the court will not be in a position to assume that there is any truth in the plea of self-defense. Thus, it would be for the accused to adduce positive evidence or extract necessary information from the witnesses produced by the prosecution and place any other material on record to establish his plea of private defense. The right of private defense is necessarily a defensive right, which is available only when the circumstances so justify. The circumstances are those that have been elaborated in the IPC. Such a right would be available to the accused when he or his property is faced with a danger and there is little scope of the state machinery coming to his aid. At the same time, the courts must keep in mind that the extent of the violence used by the accused for defending himself or his property should be in proportion to the injury apprehended. This is not to say that a step-to-step analysis of the injury that was apprehended and the violence used is required to be undertaken by the court. Nor is it feasible to prescribe specific parameters for determining whether the steps taken by the accused to invoke private self-defense and the extent of force used by him was proper or not. The court's assessment would be guided by several circumstances, including the position on the spot at the relevant point in time, the nature of apprehension in the mind of the accused, the kind of situation that the accused was seeking to ward off, the confusion created by the situation that had suddenly cropped up resulting the immediate reaction of the accused, the nature of the overacts of the party who had threatened the accused resulting in his resorting to immediate defensive action, etc. The underlying factor should be that such an act of private defense should have been done in good faith and without malice. The records reveal that border fencing in the area in question was erected just a few months before the incident took place. Prior to that, many villagers used to freely indulge in smuggling activities by crossing over to the Bangladesh side and vice versa. A couple of months after the fencing was fixed along the international border with Bangladesh, there was an incident where the smugglers assaulted one of the members of the battalion when he was trying to prevent them from crossing the border. That the deceased used to indulge in smuggling activities and his name was mentioned in the list of smugglers maintained by the BSF is also a matter of record. On a broad conspectus of the events as they unfolded, this court is of the opinion that the right of private self-defense would be available to the appellant, keeping in mind preponderance of probabilities that leans in favor of the appellant. In fact, situation where he was suddenly confronted by a group of intruders who came menacingly close to him, were armed with weapons and ready to launch an assault on him. He was left with no other option but to save his life by firing at them from his rifle, and in the process, two of the shots pierced through the deceased, causing his death. Thus, the appellant ought not to have been convicted of having committed the murder of the deceased. Rather, the offence made out is of culpable homicide not amounting to murder under exception 2 of section 300 IPC, thereby attracting the provisions of section 304 IPC. In view of the aforesaid discussion, the impugned judgment is modified to the extent that the appellant is held guilty for the offence of culpable homicide not amounting to murder as contemplated under exception 2 of section 300.